One bottle of ginger beer, one decomposed snail, and a woman named May Donahue. That 1932 moment set off a chain of cases that built the entire modern law of negligence, and it's still being refined today. In this video, we're tracing the key milestones in the development of negligence law in England and Wales, from the birth of the neighbour principle through to the Supreme Court's most recent word on how the duty of care test actually works. Before 1932, the tort of negligence was fragmented. You could only sue for negligence if you fell into a recognised category, employer and employee for instance, or users of the highway. May Donahue's case blew that open. She drank ginger beer from an opaque bottle bought for her by a friend and found a decomposed snail inside. Because she had no contract with the manufacturer, the old approach gave her no remedy. The House of Lords disagreed. Lord Atkin articulated his famous neighbour principle. You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbour, meaning anyone so closely and directly affected by your act that you ought to have them in contemplation. This created a general, open-ended duty of care in tort for the first time, and it remains the philosophical foundation of negligence today. The next major extension came in 1964 with Hedley Byrne v Heller. The question was whether a duty of care could arise from words, specifically a negligent misstatement, rather than a physical act. The House of Lords said yes, but only in restricted circumstances. Where there is a special relationship between the parties, meaning one party has relevant skill or expertise and the other reasonably relies on their advice, a duty will arise. Crucially, the party giving the advice must have voluntarily assumed responsibility for it. This opened the door to claims for pure economic loss, which ordinary negligence claims cannot recover, and it remains the leading authority on liability for negligent advice. By the late 1970s, the courts were looking for a more systematic framework. In Annes v Merton London Borough Council in 1978, Lord Wilberforce offered a two-stage test. First, is there a sufficient relationship of proximity based on foreseeability such that a prima facie duty arises? If yes, move to stage 2. Are there any policy considerations that ought to limit the scope of that duty? This test was ambitious. It essentially presumed a duty existed unless policy said otherwise. It was criticized almost immediately for opening the floodgates too wide, particularly for public authorities and for pure economic loss claims, and it had a relatively short life. The decisive response came in Caparo Industries v Dickman in 1990. The House of Lords replaced the Annes test with a three-part test for novel duty of care situations. The claimant must show, first, that damage was reasonably foreseeable, second, that there was sufficient proximity between the parties, and third, that it is fair, just, and reasonable to impose a duty. Importantly, the Lords also endorsed an incremental approach. Courts should develop the law step by analogy with established categories, not by leaping from general principle. Caparo has remained the central authority on duty of care ever since, though its precise role was later refined. Shortly after Caparo, the House of Lords in Murphy Vorford Brentwood District Council in 1991 took the opportunity to formally overrule Annes. The case involved a local authority's negligent approval of defective foundations. The Lords held that the cost of repairing a defective building is pure economic loss and is not recoverable in negligence, a direct reversal of Annes. This decision confirmed the restrictive post-Caparo direction of travel, and it also clarified the boundary between tort and contract. Where a party has suffered only financial loss with no personal injury and no damage to other property, negligence is generally not the right vehicle. The most recent major milestone is Robinson v Chief Constable of West Yorkshire Police, decided by the Supreme Court in 2018. Mrs. Robinson was knocked over by drug suspects being pursued by police officers. The case went to the Supreme Court partly to clarify how the Caparo test should be used. Lord Reed gave important guidance. Caparo is not a routine three-part checklist to be mechanically applied in every negligence claim. Instead, when an established duty category already covers the situation, courts should follow precedent by analogy. The Caparo principles, foreseeability, proximity, fair, just, and reasonable, are reserved for genuinely novel situations where no prior authority gives clear guidance. This brought welcome clarity and prevented Caparo from becoming a vague, all-purpose formula. Here is your check for understanding question. After Robinson v. Chief Constable in 2018, how should courts use the Caparo test? Option A, in every negligence claim as a routine three-part checklist. Option B, only in novel situations not covered by existing precedent. Option C, only for public authority defendants. Option D, only where pure economic loss is claimed. The answer is B. Robinson confirmed that where an established duty category already applies, courts follow precedent by analogy. Caparo's three-part framework is for genuinely novel duty questions only. From Lord Atkin's neighbour principle in 1932, through the rise and fall of the Ann's test, to Caparo's incremental framework and Robinson's clarification in 2018, negligence has evolved from fragmented categories into a principled, carefully controlled area of law. Your modules, mapped to your uni, explainer videos for every topic, a tutor that knows your course, essay writer for your essays and graded, case briefs, flashcards, annotations, try it free for 7 days, link in the description.